Lordship,
Yes.
I beg to mention item number 7. This matter may be listed for
Huh?
this may not be listed in the mediation draft. The party is not ready.
The parties are not willing to agree with the mediation.
Okay. Heard, Mr.
Yes, Your Honor, Lordship.
You are appearing for,
Petitioner,
your name?
BD Esther,
So and so, the learned counsel appearing for the petitioner as well as Mr.
Yes, Your Honor, Lordship.
So
For
and so
respondent number 4.
for the respondent.
Respondent
the-
number 4, Lordship.
For the respondent number 4. Respondent number 4 is who?
Private respondent.
Private respondent. The counsel appearing for the parties jointly submitted that they are not willing to they are not desirous of placing the matter before the mediation center, Guwahati High Court, Itanagar Permanent Bench for resolution. Accordingly, in view of the aforesaid, they let the matter be listed for admission in the usual course.
After 4 weeks.
In usual course after 2 weeks.
4 weeks, Lordship. 4 weeks.
Why 4 weeks? Why so much of time? Why 4 weeks? 3 weeks. Okay. After 3 weeks. Yes.
Leave them.
deeply obliged. Your Lordship, I beg to mention item number 6 on behalf of K lawyer.
Mm.
And the matter may be fixed for hearing.
Okay. So and so the learned counsel appearing for Mr. K lawyer, the learned counsel for the petitioner submits that the matter should be listed for hearing in the usual course. Let the matter be listed after 2 weeks.
Okay. Deeply obliged, ma'am.
May I please, Lordship? To mention one criminal petition for today.
Today not possible.
So, it's
Next week.
personal liberty, no, because without registration of FIR, this 35(3) has been issued.
So 35(3) is only for this thing, appearance.
Yes, but no FIR is registered. Without registration of FIR.
That will look into it, that will look into, but this is not how come it has become personal liberty now? You have been just asked to appear.
Lordship, that Lalita Kumar is clear, Lordship, that without registration of FIR in violation of Article 21.
Monday,
Yes, sir.
Monday. It will be released. It won't be possible today or tomorrow. There are so many matters. Monday. Let the matter be released on Monday.
Item number 1.
May I please, my lord? My lord, this bail application is arising out of Alo Women PS case number.
One second. Mr. Counsel, when have you been asked to appear? By the notice? You don't have any information.
Now, course of 11.
It has gone. Time has already gone. Okay, Monday will take. Yes.
Alo PS, Women PS case number 0.
The POCSO.
Yes,
POCSO
my lord.
matter.
Yes, my lord. So I have been arrested on 26/3/2025. Almost
Has been alleged to have committed rape on the victim girl, who is happened to be the daughter of the informant. Full stop. On receipt of the FIR, the Alo police station case number 04/2024, and that aforementioned section was registered. Let notice be issued on respondent number 2
Lordship,
So-
through Office of PP, Lordship.
through the registry, as per the prevailing notification. Prevailing notification issued by the Guwahati High Court. So it will go to, for registry, it will go to.
Yes, Lordship.
the Guwahati High Court, full stop. A notice to respondent number one is dispensed with as the running APP enters appearance for respondent number one. Call for the trial court record.
Yes, right.
Call for the trial court record in connection with Alo Omen PS case number 04/2025. Pending before which court?
Session, Lordship.
Pending before the session court, man.
Pending before
Special Judge Bokso
special
Alo.
POCSO, Alo.
Alo.
Let the matter be listed after. Let the matter be listed when?
2 weeks, Lordship.
Any date?
Lordship.
Let the matter be listed on.
TCR will come, Lordship.
So anyways, we'll fix a date. Let the matter be listed on 25th
Yes.
March.
Yes,
25th March.
obliged.
Obliged, Lordship.
Item number 2,
May I please your lordship?
Hmm.
Lordship, this 482 application has been filed by the petitioner praying for granting PRS bill to the petitioner on apprehension of arrest, lordship, in connection with complaint arising out of an agreement dated 8/3/2025. Your lordship will find the agreement at page number 13, lordship. Lordship, as per the agreement, lordship, the petitioners entered into an agreement with one lordship Sri Tesi Taja Sera, lordship, for construction of a building. They have to work as a lordship mason and a labor in the construction work, lordship. As per the agreement, lordship, they have discharged the work, and I have categorically stated in my lordship paragraph 3, lordship, that as per the agreement, lordship, they have already constructed, lordship, one safety tank and one guard wall apart from the lordship, the first floor of the building. Thereafter, lordship, since the first person, lordship Tesita Tera, lordship, could not supply the raw materials for the building, they should have to left the places of the because of they cannot spend their days without any remuneration or without any wages. But as per the agreement and lordship clause 5, lordship, they have been bound to stay there, lordship, until and unless the work is completely done, lordship. In fact, there is no condition that whether the first party can supply the raw material or not, lordship. As per the clause 5 of the agreement, it is reflected in the page 13, lordship. And the Tesita Tera, lordship, he is also a police personnel, lordship. Thereafter, lordship, continuously, lordship, the one of the investigating officer of the lordship Doimuk police station continuously, lordship, calling to the petitioners, and they have been directed to appear before the police station, lordship, for settlement of the disputes, but they have not informed on what ground, on what basis the FIR.
Any FIR, no FIR filed.
Lordship, as per them, lordship, the complaint has been filed, they have not registered. And so far, the Supreme Court, Honorable Supreme Court, in the judgment of Gurbakh Singh Sibha, and finally, lordship, the Honorable Supreme Court, led by 5 judges of the Honorable Supreme Court, also affirmed that, lordship, FIR cannot be a condition precedent for granting of PRS bill to the petitioner. Only sufficient ground of apprehension of arrest is, lordship, that only need to be there in the lordship petition, lordship. Because they have to work not only in Assam, lordship, they have to work in Arunachal Pradesh. As and when, if they will pick up from the workplace, then both will suffer. Either lordship, the owner of the building will suffer, and lordship, the labor, they will themselves suffer, and their family will suffer, lordship.
Yes, Zini.
Yes, Your Lordship, with regard to the FIR, Your Lordship, he himself has stated that there is no FIR on
Yes.
2 occasions they made an inquiry, but then there is no registration of FIR. Also, Your Lordship will see the respondent number 2, Your Lordship, why was he made a party to this petition?
Lordship, he is the
Because
respondent number 2 is the Sahabuddin, lordship. He is the one of the witness in the petition, and he has been called by the lordship investigating officer of the Doimuk police station, lordship.
Yeah, Rabiul is the mason.
Yes, your lordship, and
Shahabuddin is the,
he is the labor of the lordship.
and what respondent number 3 you are talking about?
Respondent number 3, lordship,
There is no respondent number 3.
Yes,
there is no respondent number.
petitioner number 2.
Petitioner number 2, he's a mason there, mason and helper.
Yes, but then there is no affidavit to his even in this petition. Your Lord.
Lordship, the affidavit has been sworn by the lordship
No, what is
Rabial
the-
Hussain on the authority of the, he can, lordship, sworn for all the petitioners on, if they have been authorized as per the High Court rules, lordship. There cannot be a separate affidavit for all the petitioners. If there is 10 petitioners, then it not need to be filed separate affidavit.
But
for
you have
and-
not made a statement that you have been authorized.
Lordship,
There-
I am competent to swear this
There is one,
on being authorized. I have written there in the,
On being authorized by whom?
on being authorized.
On being authorized by
I am
whom?
competent to swear this affidavit on behalf of
All the
all the
petitioners.
petitioners.
This is
Just
fine,
there.
Mrs. Ginny.
no, your lordship, there is no authorization even in my petition, your
Hmm?
lordship. There is no authorization in my petition, your lordship.
No, I mean,
Once an author-
this affidavit has been sworn in on behalf of both of them.
Normally, your lordship, when one of the applicant swear on behalf of the other applicant, your lordship, there is the authorization
That, I
letter
mean-
has
I
to be
mean-
annexed.
It was, lordship, it was never.
I mean,
yes, listen, lordship.
that is a small technical hits. I mean, this affidavit specifically said that he has been authorized.
Yes, your lordship, in that connection, authorization letter has not been annexed along.
No, correct, but on an affidavit, the statement has been made, that suffices. That will suffice. But on the merits, what do you want him?
Other ground, your lordship, there is no FIR to that effect, your lordship. There is only
But he has an
and,
apprehension, he has been called, the phone numbers have been
the
given.
phone numbers, we are not aware whose phone numbers are these, your lordship. This
But
phone-
he has
one of
serious
the-
apprehension.
The phone numbers given does not reflect any, if it's of any of police personal's number, your lordship.
The person who introduced himself as an investigating officer of
there
the
is-
Doimuk police station and his police
But,
phone
but
number
this is a Tamil Nadu mobile telephone. What is this Tamil Nadu mobile telephone?
lordship, nowadays, lordship, what happened, if a person called lordship, it is only shown in the lordship, from the true color that he is calling from and where his mobile has been registered. It is normally, lordship,
Then this is
happens,
Northeast
lordship.
mobile tel, what is, I don't know.
Lordship, it is a lordship, auto-generated lordship, this through the true color system, lordship, not from the lordship telecom system.
You take instructions,
I'll just take instruction.
take instructions, we'll just allow him to some interim protection. You take the instructions.
Yes,
Heard Mr.
This,
D. Sharma, the learned counsel appearing for the accused applicants, also heard Ms. M.S. P. Gini, the learned APP for the state. There is an application under so and so. Then we write the case of the petitioners. The case of the petitioners is that the petitioners, being a mason and a helper entered into an agreement on 8/3/2025 with one Sri Teki Taje Tara, resident of Gamto number 2, Gamto 2 village, PS Doimuk, to the effect that at the rate of 230 per square feet, they will complete the whole scope of the work of building of a RCC building,
yes, your Lord.
RCC building with other ancillary constructions. Constructions, full stop. It was also agreed in the agreement that till the completion of the work, the mason and his helper will not leave the place of construction, full stop. The case of the petitioners is that though they have completed certain portion of the work, including a septic tank as well as the ground floor of the RCC building, after that, due to non-supply of raw materials, they could not complete the whole scope of the work, full stop. In fact, since no payment has been made to them for their survival, they had to leave the place of occurrence for searching for other works in other places. Full stop. It is stated that after they left the place of occurrence, they went to different places for searching jobs, searching for work, and they have been working where you have been working now. They have been working in
Working at Lordship Bipuria.
they have been working in Vipuria at present, and they received several calls from the aforesaid Teki Tazetara, who is an inspector.
Lordship, he is called as a officer in charge of the Doimuk police station.
He is supposedly the officer in charge of Doimuk police station, and asking them to come back to the work, or otherwise they will be arrested. Full stop. The petitioners stated that since they are yet to complete the work in Vipuria, they were unable to come back to the place of work in Doimuk. And therefore they requested for some time. However, the aforesaid Teki Tazetara had been threatening them over the phone that if they do not come, they will be arrested. Being apprehensive of their arrest as the caller himself is the officer in charge of the aforesaid Doimuk police station, they have filed the instant pre-arrest bail application, being seriously apprehensive of their arrest. They further stated that due to their involvement in the kind of work, they need to visit Arunachal Pradesh as well as state of Assam for their livelihood. Full stop. They further state they stated that though an FIR may not have been lodged in the instant case, they are having serious apprehension. After then you write MS PGNI, the Learned Council, Learned APP, and submits that she will take instruction in the instant matter, full stop. Upon hearing the council appearing for the respective parties, this court is of the considered opinion that at least till the time the Learned APP takes instructions in the matter, the accused applicants should be protected on an interim basis. Therefore, it is directed that no coercive action should be taken against the accused applicant till the next date of listing of the matter. Let the matter be listed on when.
Monday, Your Lordship.
On
16.
No coercive action. No
24th,
coercive action till you come up with the instruction.
24th, Lordship.
24. Let the matter be listed on 24th.
Lordship, only my humble submission before this honorable court. Once sub-inspector who called himself as the investigating officer of this case, Lordship, his number has been inserted in my petition, Lordship.
No, that will be let her take instruction. Let her take instruction what is happening, and on the next date, your prayer of bail will be considered.
Highly obliged.
Let the matter be listed on 24th. No coercive action till then.
Item number 3.
May I please, Your Lordship? Yes.
Lordship, your lordships, this criminal petition is jointly filed by both the petitioners, 1 and 2, under section 520 of BNSS, read with section article.
What was the case?
It's case of cruelty.
Cruelty.
Yeah.
Husband and wife.
Yes, Your Honor.
Huh?
Yes, your lordship.
That case, that extramarital affair and all. Yes,
No, Lordship, actually, last time, Lordship, if you remember.
because that deed of divorce
Yes,
was
yes, yes,
given. na?
Lordship, exactly, Lordship.
Now you have come up with a different agreement.
They have come up with the settlement agreement, Lordship. Section 85 BNS, Lordship.
So it's a marital dispute.
Yes,
I
Lordship.
mean, we can
Ah.
close this.
Yes, Lordship, I have no objection also.
I'll pass the order. You just write the names. I'll pass the order in the chamber.
Yes.
That similar order will go. That's, I mean, that is there with Jumi and Mariam also. So, I mean,
Obliged, Lordship.
Sure, DP obliged.
Item number 4,
Met this orders. Lordship, herein Lordship, learned conducting counsel, Mr. Pangin is on legs at the court number 2, Lordship. And it may take some time, Lordship.
so we'll post it over in the next week.
Lordship, kindly it may be taken up on Monday, Lordship.
Okay, Monday. Mr. Swenso, the council, Deepanging. He submits that Deepanging is occupied in some other matter and therefore prays the matter to be listed on 16. Prayer is allowed, let the matter be listed on 16.
Obliged.
item number 5,
May I, Lord, Mayor, please? This criminal petition, joint criminal petition
Hmm.
for the quashing of the FIR.
What is the offense?
Offense, wrongful restraint and grievous hurt only.
Hmm?
Wrongful restraint and grievous hurt.
Grievous hurt.
Yeah. Matter has been already settled with the consent of the body parties and initiated by the parents of the body parties. Actually, they are the relatives, matrimonial relatives. So settlement has already done. I have annexed the settlement copy. Annexed the settlement copy in page number 21.
But you cause grievous hurt, then you settle it, you pay money or what?
Already, already there, already has been medically cured. The injury has been already healed.
So you have filed this jointly,
Yeah, jointly. Petition number 1 is the informant, the
And
victim. And
victim.
petition 2 and 3
The
is the,
petitioner one suffered this thing.
yeah,
He suffered
Yes,
the
yes.
injury.
yes, Your Honor.
Then petitioner number 2
2 is the LS accused, 2 and 3 is the LS accused.
is accused.
Yeah,
So
yes.
they compromise now,
Yeah, yes,
the
Your Honor.
agreement.
Yes.
Okay, Mr. Tado, you have some objection?
in FIR,
No, do you have any objection in this?
yes, there are more than one persons involved in this case.
The 2 persons there.
2 persons.
2-person name is different. That is Tasar Tate, another one is name in FIR. Ram Tayam is in
No, no,
settlement.
who is the victim?
Tamahuli.
Huh?
Tamahuli.
Victim is,
Number one petition.
victim is number 1.
Yeah, number 1 petition. Yes, Honor.
Victim is number 1,
Victim.
Tamatuli.
Tamahuli.
And accused,
Accused is Ram Tayam.
Ram Tang, Raja Tang,
And
and who else?
Only this, both of this only.
Yeah.
And in
All-
FIR, it is named as Tasar Tate.
Your Honor, already police has been served a notice and brought them under police station, and they have joined the-
But FIR, there is another name. Ram,
Police has been already released both the LS accused also.
is there any person called Tasa Tate or something?
Maybe wrongly this written. Maybe typical mistake.
I mean, this is, the case is at what stage now?
Only in the FIR is this.
Only FIR stage?
Yeah. Yes, ma'am.
Do you have any information about like Tasa Tate, any information? We'll close this, Mr. Tata.
Hmm.
Nothing in this one. Same order will go. Similar order will go. Compromise position. Okay. The FI stays. I will dictate in each one. Take down their names. Okay, we'll close this.
Item number 8, much obliged.
Yeah.
May I appeal also?
Yes.
My lord, this is a revision against conviction. There is a concurrent finding by the learned court below, both appellate and the learned trial court. The petitioner herein before your lordship was convicted under for offense under section 326. Livial cert. By judgment and order dated manner 12/20 and 5/6/2005, it was affirmed. Now kindly see the FIR page 1 of the paper book.
This item number,
Item number 8.
why we have not taken this bail order, sir? Huh? Bail order আগত দিব কৈছিলো না মই। Instruction দিয়া proper report. Yes.
Yes, my lord. Page 1 is the FIR, my lord. Petitioner was convicted for offense under 326.
Page 1.
Page 1 is the FIR.
Page 1 is the FIR
Yes, my lord. In the paper book, my lord.
of paper book.
Yes.
Yes.
Yes, may I read, my lord? I have the honor to inform you that today on 10/5/2012 at about 17:30 hours, one Sri Madhav Sunwal, place so and so, has suddenly attacked me.
You are reading from,
Paper book, my lord.
yes, page 1.
Yes.
Yes.
I have the honor to inform you that today on 10/5/2012 at about 17:30 hours, one Madhav Sunwal, son of so and so, place so and so, has suddenly attacked me with sharp weapon that is local dog at place Podumani without any reason. As a result, I sustained severe cut injury in my head. This is the allegation. This affair was lodged by the victim, my lord. Then accordingly, search sheet was filed by the police under section 326. The search sheet is start from page 2 onwards. Then,
Now go to the depositions.
yes, my lord. First, my lord, can you see the deposition of the victim, my lord?
Hmm.
He is the PW2,
Page,
page 12. Page 12.
yes.
May I read, my lord? I have the honor, I have came here as a witness in connection with my case. I know the accused since my childhood. We being from the same place, Podumani, Mandeko. Sometimes in the year 2012,
Can go and look at this, this, information. You can give it to Gindi or to the, you can pick up. It'll take some time. Yes.
when I was coming back with my bike after dropping my uncle, Populo Mess, to his residence at the same place, Podumani.
PW2, I mean, I have come here as
Yes.
a witness so and so, yes, read. I know the accused since childhood.
I know the accused.
Hmm.
I came back with my bike after dropping my uncle.
I was coming back with my bike. Where is the
Yes.
came back?
I was coming back with my bike after dropping my uncle.
Hmm.
From the same place, after dropping his uncle, he came.
Hmm. To his residence.
to his residence at the same place,
Hmm.
Kodumani. The accused cut me on my forehead
Hmm.
without any reason.
Hmm.
Without realizing the gravity of the cut injury sustained by me,
Hmm.
I reached my home while driving bike, but on reaching, I realized and see that pool of blood was oozing out of my head.
Hmm.
Thereafter, I, along with my elder brother,
Hmm.
ran to mess.
Hmm.
Mother went to the police station Mahadevpur and then to PHC Mahadevpur.
Hmm.
After stating my injury and first aid, we returned our residence, where I became unconscious. To came back to my conscious at
Only to come back to my consciousness at hospital Dibrugarh, yes.
Yes, Dibrugarh.
Hmm.
This may be noted, Mano, at
Hmm.
hospital Dibrugarh.
Hmm.
Before that, he came back after first aid and all. Nothing was happened. The incident was happened.
After stitching of my injury and
Yeah.
first aid, we returned to our residence
Yes,
where I became unconscious.
unconscious.
Only to come back to my consciousness at hospital Dibrugarh.
Dibrugarh.
So he got unconscious, so he was taken
So
to
he was
Dibrugarh.
taken to hospital at
Correct,
Dibrugarh.
correct.
Correct.
When
When I went to police station Mahadevpur,
Mhm.
I was examined by police
Hmm.
in this case.
Hmm.
I do not remember the lodging of formal affair, which is exhibit 2,
Hmm.
paper exhibit 2 and paper exhibit 2A is my signature.
Hmm.
If permissible in law, under law, this case may be disposed of at the earliest stage, as I have no grievances against the accused person,
Mm.
as he being my brother-in-law and co-brother.
Hmm.
But the actual weapons of offense which was seized is not shown to me today in this court,
Hmm.
in the cross, my lord. I do not know the contents of FIR exhibit number 2, dated 10/5.
Who had filed the affair?
FIR was lost by the victim himself, Digonta Mess,
Hmm.
but he said he do not know.
Hmm.
But actually, it was lost by his father. Though his signature is there, man, victim signature. is-
That time of occurrence of the
At the time of
incident?
occurrence of incident, it was between 14 to 16 hours. In
Hmm.
between, 2 to 4
Hmm.
in the afternoon.
Yes.
It was not a fact that injury I sustained was due to my own fall
Hmm.
with my bike while binding my head and seeing the accused running towards me holding garden down. This is the suggestion, my lord. It is not so important. Then, my lord, can you see the medical report, my lord? This-
Yes. Medical report where?
The medical report.
There is no eyewitness in this case.
There is one eyewitness, this PW3.
So where is his statement?
Yes. PW3.
His eyewitness.
He is the eyewitness is
Hmm.
PW3.
Page
Page
15.
15,
Eyewitness.
eyewitness.
Hmm.
He said he was there at the time of
Now
incident.
let's see what he says.
May I read, my lord?
Hmm.
I know the person in the accused box whose name is Madhav Sunwal. Some years back, the exact time I do not recall, but it was evening after attending the marriage a function. I was proceeded towards my village Kodumani, Mahadevpur. On the way, I happened to meet one Akhil mates of our same place. While we were talking to each other, we saw the victim Digonta Das riding in a motorcycle with high speed. And meantime, suddenly the accused hit the victim with his local dao on the victim's head, due to which the victim sustained injury. Blood was also oozing from his head injury. Thereafter, the accused left the spot and victim came towards us. However, looking at the victim who sustained injury with blood, I became nervous and left the spot to avoid the complicity. After a few days of the incident, I was summoned at Mahadevpur police station, and there I identified the weapon of offense, local dao, out of which the 6 dows shown to me by the police. I also gave my statement to the police. Exhibit 1 is the seizure list of weapons of offense, then exhibit 1B is my name and signature. I can identify the weapons. The cross, he said, in the cross, when I saw the accused, it was the distance of 100 meters. They are on the, not in the same place. Meantime, I saw the victim riding the motorcycle with speed from the opposite direction. I am not sure whether the victim was injured with sharp or blunt side of the dao used by the accused. I did not take the accused dao of the accused I did not take the used dao of the accused with the father of victim from the spot, but I saw the victim himself picking up the weapons of offense from his left, after which I did not see where it was taken, as I have walked away from the spot as well as from the victim. It was not the fact that victim had hit the accused with his bike, because of which he went to the street to his house without stopping even for a while. I have not seen the weapons of offense down in the fort. It is not the fact that I did not talk to Okil Mes when I showed to the victim with his bike. This is the one of the witness, my lord. Now, my lord, the injury part, my lord. Assuming there is a injury
Who is
part,
PW5
PW5, my lord. IO. PW5 is the IO, my lord.
and PW4?
PW4 is the doctor, my lord.
Yes, let's see what
His-
doctor
his
says.
testimony is also important, my lord.
Hmm.
My lord, before that, my lord, injury report may be there. Still, my lord. Page 8.
We'll see, then you see first PW4.
PW4, my lord. There is the doctor, MC Manse. In 2012, I was posted at Mandu PS as a medical officer. I have been summoned by the court in connection with the injury sustained by Devon Thomas. On 10/5/2012, at around 1750 hours, above injured person was brought to CSC Mandepur by the Mandepur police. But I do not know in which particular case. Accordingly, I examined the injured person. Upon examination, I found sharp cut injury, upper right side of the
12 inches means, I mean,
Yes,
1 feet,
1 feet. 1 feet.
1 feet and wide,
The length
the
of the
length
cut
of the
portion was
one and
10 to
width of
15
the
inches.
injured person is not very clear to me,
Yes.
but there was a gap.
There was a gap,
I also
And-
found, who is this guy?
close bleeding.
Age Heli. What is his name?
No, my lord, his name
CL Manse.
CL Manse.
He's a doctor.
He is the doctor. CL Manse.
Found loose bleeding from the injured person.
Yes. And this report is at page 8.
Yes,
Yes, my lord, kindly see page 8. The incident occurred at 2, my lord, 2 to 4. He was examined at 6:30 p.m. The affair was lost in 17:50.
Hmm?
Affair was lost around 5:50, 17:50 means around 5:50.
yes.
Yes, injury report, my lord, page 8.
Now 12 inches, he
Cut.
already said so.
Cut injury, side of the scalp over the ear, gibbous sharp open. The date of examination is 10/5/2012.
Now, can we disbelieve this?
My lord, whether, my lord, 12-inch can be believed.
That
Human
med-
hand, my lord.
that medical expert will know. How
Yes,
this
my
court
lord.
will know.
Medical expert will know, my lord.
Hmm.
He was taken to Dibrugarh.
Hmm.
The victim also says, I was taken to Dibrugarh.
That's why he was taken to Dibrugarh probably.
Yes, no, my lord. The incident occurred at 4, at best at 4. He said between 2 to 4. So then thereafter he went to police
He went to
station.
his house
He went to his house, then he went to
Police station.
then police station, he went to hospital.
Hmm.
In that period, more than 2 hours, 3 hours,
Mm.
nothing was happened. If it is so grievous, suppose I'm assuming there is an injury.
Hmm.
If it is grievous,
Mm.
cut by a sharp weapon, he could not move. That's also 12 inch,
12
Can
is
it-
length only, na?
12 in length.
Maybe a scratch. How do you know?
Yes, my lord.
Maybe maybe
If
a
it is
scratch,
a
maybe,
scratch, then it
maybe a
is
scratch of 12 inches, but in between maybe there are some deep cuts.
yes, if maybe a scratch, then it is a simple injury.
No, I mean, there
My
may be
lord.
cut in between.
My lord, Can it
See,
be,
the,
my lord?
if you put the dowel,
Yes,
dowel may not hit
That
the
also-
whole person.
there's also coming from opposite direction with a high speed.
But those are presumption and assumptions.
My lord, can it believe? Now my second, my lord, he was taken to Dibrugarh. He
So
said,
he was previously
Yes,
injured.
my
in
lord.
fact. Probably he was given stitches. Then, I mean,
No,
there was no
my lord.
mention of stitches.
kindly see the statement of the testimony of the PW1 father.
Hmm. Whether stitches were given or not. Yes,
That was not mentioned.
Hmm.
It was not there.
Hmm.
PW1, my lord, father.
My victim, some due to the cut injury shoved down on his forehead
Yes, correct.
by the accused, remained unconscious for 5 days while
4,
in
5 days
ICU.
while in ICU in private hospital.
Aditya Dibrugarh.
Auditor, but
Hmm.
none of the documents
Hmm.
or medical report
Not
has been
required, not required.
activated
Not,
or produced by the prosecution, my lord.
not required. What is the investigation officer saying?
My lord, kindly see the investigation officer whether he has collected any document.
No, whether he has stated that he has stated that he has taken to the Dibrugarh.
No,
Are you disputing that he was taken to the Dibrugarh?
my lord,
Let's see PW5.
yes, may I,
PW55 is the officer, right?
he is the IO.
Let's see.
I have came here in compliance of someone issued to me by this court in capacity of IO of this case. I cannot identify the person I standing in the dock. My IO being, he cannot identify it also. In
What?
2012, I cannot identify the person standing on the dock. He is the IO man, but he cannot identify. In 2012, I was posted at Mandibu PS as its OC. Upon receipt of the FIR on 10/5/2012 from 1 Sri Digonto Mess at around 1750 to the effect that on the same day at about 1730 hours, 1 Sri Madhav Sunwal, son of so and so of Blessed Podumuni, attacked him with sharp weapon local dao, due to which he victim sustained injury. The case was registered formally by Mandipu PS case number so and so under section 326 IPC. After registration of the case, I have forwarded the victim informant to the CAC Mandipu for necessary medical treatment, which I had visited PO, but neither I could arrest the accused nor seize the weapons of offense, as the accused has already fled away from the place of occurrence. Then I examined the loan prosecution witness Suken Gugoi, the PW3, and recorded his statement. Later on dated 12/5/2000, I seized the weapon.
Where is the charge sheet?
Yes, one of charge sheet. Charge sheet is start from page 3. Page 3.
Page 3.
Yes, charge sheet was filed on 30/11/2012. Here also said length of the dowel is 1 inch and 10-inch length. He never mentioned that he was even referred to medical college at Dibrugarh.
But in your defense, whether you could cross-examine him on this, whether he could destroy this, rebut this.
My lord, in the cross, it is not, nothing is there.
Then
Only
that has
state-
to be believed. If there are now no other contradictory statements or anything which really
My lord,
contradicts that
It is
statement.
the duty of the prosecution also, my lord, if he was taken to whether any medical document of the Dibrugarh hospital has been produced, whether it was
See,
attributed.
see, Mr. Counsel, it depends upon case to case. If the case is apparent, if those documents are not required to be given, why the prosecution will do that exercise? Prosecution will do the exercise only to the extent that if they need to gather sufficient information, sufficient evidence against the
Ac-
accused. And if they find that there is no evidence, then they will not file the charge sheet. And if they find the evidence, they'll file the charge sheet. That is the prosecution, duty of the prosecution.
Yeah.
In this case, that was not required. I mean, there is already a medical report stating that 12-inch cut has been done.
Yes, but for that, my lord, whether 326 is applicable,
Hmm?
ABS heart. My lord, so assuming there is a card mark, the offense has been committed. Whether 326 is applicable, my lord.
The grievous hurt.
My lord, it is the,
I see,
Except-
there is an opinion, there is a medical opinion saying that
yes, my lord.
that is a grievous hurt and that is a,
ABS heart, my lord.
listen, there is a grievous hurt and it is cut is in the nature of a grievous hurt, and there is a statement from the father of the victim that he was, and that statement of the father of the victim, you could not demolish that. That statement stays in your defense. In your defense, he could not demolish that. 313, what is there?
313, my lord, 313 is start
Base 23.
23. Yes, strictly denied. I had the motorcycle bike while having drink with my residents at Podumini. Electronic cycle. I do not know whose motorcycle it was. What happened with the victim Digonta Mess? As such, I do not know what I got victim. EW3 can go and
But he's supposedly your brother-in-law.
he is my brother.
Then where you absconded your
Eh,
conduct,
My lord, no kindly.
you were not found in your
It
place.
is not the case that I have not helped them. My lord, kindly see a statement of PW 1.
Hmm.
Only grievance, I think, my lord, I have not paid the medical expenses. That is the father of
So let's see,
page 9.
what is that?
Page 9.
What is that? Thereafter, on returning village, I lost the FIR.
It was
Copy.
lost by it was not lost by him. I have came here as a witness in connection to
No, forget about the other one.
yes.
Now, come to the bottom.
Thereafter, on
Thereafter, on
returning village,
returning to my village, I lost the
the
FIR.
FIR. But the copy of FIR shown before me in this court is not the FIR which I had lost.
Lost.
I spent 50,000 towards the medical expenses of my
Victim.
victim son. The accused gave only 15,000. Apart from that, no further payment were made, nor any approach to console us. Or
To share the
share
expenses of medical
treatment.
It's a genuine grievance of a villager. Genuine village of
Yes, my lord.
genuine
Yeah.
grievance of a villager is that his son was, grievously injured. He spent
But-
50,000 rupees, and this person has accused person has paid 15,000, and he absconded after that. He never came back to them, consoling them, also saying that I'm sorry, nothing. That's what he's saying.
That's what
That's
he
a
said.
simple expression of a father who is a villager when his son was grievously injured by one of the relatives,
Yes,
and that too one of the relatives.
yes.
Then
Now, whether the offense falls under 326.
why not? This is a grievous hurt. It already been
Can section 320.
yes. Still read what is there. BNS. BNS, yes.
And it's IPC, man.
BNS, what is that? 120?
120.
Okay, that, from, read from IPC.
Yes, my lord. Definition of previous.
Page, section,
Section 320, man.
to section 320.
Married.
Conviction was for how many years?
2 years, man.
So he's inside the jail for how many?
6 months now.
Six months. Page 320, sorry, 326.
320, section 320.
Hmm.
Following kind of heart are only designated as the deviation.
Now, you are reading which one?
My lord, section 320.
Section 320, the definition you are reading.
Yes, ma'am.
Yes. Emasculation, permanent
Emasculation,
privation of slighter eye, permanent privation of any member or joint, destruction of permanent so and so, permanent disfigure of head or face, fracture or dislocation of bone, tooth, any hurt
Yes, my lord.
which endangers the life and which causes the sufferer or
For
which
20
causes the sufferer to be during the space of 20 days in a severe bodily pain or unable to follow his
Ordinary pursuit
ordinary pursuits. Any hurt which endangers life.
or who is
No,
causes
or
suffer-
you leave the or part. Any hurt which endangers life.
Yeah.
He was in ICU for 4-5 days with injury. Is it not that his life was in danger?
But also, my lord, it would be within 20 days.
That is a different thing, mister. There are two things there. Any hurt which endangers
But-
life, that is one part.
Yes,
Or which causes sufferer. If the life, if somebody's life is not in danger also,
Hmm.
but he suffers for 20 days of severe bodily pain, then it should also give us hurt.
unable to follow his ordinary pursuit.
So two parts are there in this 328ly. There are two parts. One is any hurt which endangers life. If somebody is in the hospital for 1 day also, and that he's in danger, he was in ICU, he was fighting for life and death. But after 2 days after treatment, he comes back. That is also grievous hurt.
But my lord, in my understanding, my lord,
No, your understanding is not correct, Mr. Deori.
subject to correction, my lord.
Your understanding is not correct.
Section 326 is assuming there is a injury.
Hmm.
At best, it is a case of 323, my lord.
No, 326, 320, you are saying what? 320?
3.
Punishment for voluntarily causing hurt. No. I mean, his life was in danger. He was in ICU for 4 days.
Yes.
It's a
my
12
lord,
inches cut.
That was whole day he was
The
roaming.
12 inches cut. Have you cross-examined the doctor?
Doctor, only one doctor, the doctor at Dibrugarh, and none of the document has been produced.
No. Whether you have cross-examined, whether tried to call him,
No, I
From
have
the
not called
Dibrugarh.
him.
whether you have cross-examined that doctor who is certified that it is 12 inches cut. Have you cross-examined him?
Yes, he was cross-examined.
Then what? Could you demolish his statement? 12 inches. What have you done? Let us see.
My lord,
Doctor Pace,
he's PW4.
PW4, what have you asked? I had not mentioned cross-examination by the defense. I had not mentioned the injured person was brought to me by police. It is not mentioned injury report regarding how I had administered or treated
Yeah.
the injured person, though I had conducted all the necessary work. But have you, could you contradict that 12 inches cut was there? Did you?
No, if it is a 12-inch cut, my lord,
You are assuming and presuming whether you have cross-examined him on that. It is not a 12 inches cut.
no, it is.
How can it be 12 inches
is-
cut?
It is not
Oh,
there.
no, whether it be 12 inches cut, somebody could survive, did you ask all those questions? You did not ask anything.
That question was not asked.
You have not cross-examined
that
him
was not
properly. You have not,
Cross-examination only
you have
cut.
just asked him that what are the treatment given. Then I had conducted all the necessary work treatment, including
Including
first
first aid,
aid, stitching of the injured portion and other necessary medicines, etc. I normally not mention in the medical report about how, what and how injury was treated and administered in details.
That is only.
You
the
have not
cross-
asked anything.
That is only the process.
Whose fault is this? Defense, you could not, see, there is a specific statement and PM report stating that it's a cut of 12 inches. You are saying that how can a 12 inches cut happen? Now you have not seen, I have not seen. Now we'll have to go on the basis of the materials before us. Now, what are the materials before us? That as far as 12 inches cut is concerned, there is no dispute.
Now,
You have not contradicted that.
that portion is supposed, I only said
See,
that is not there.
you have not
That is
cross-examined,
not there.
you have not cross-examined the doctor. You have not cross-examined the father who said that there he was in ICU for 3-4 days. There was no rebuttal.
One case I relied by our High Court, my lord, is reported in 2005 1
You
GLT.
have a copy? Give it
Yes.
to me. On what point?
There is also same allegation offense under 326.
No. What point?
Point, my lord, on the medical reports.
What is that? So,
Here also offense is under 326. Cut injury in the abdomen.
yes, you, no, what is your point that you want to argue?
My lord, regarding this application of section this clause 8 of DBSR,
Okay,
it is
you, which paragraph?
is spread up 6 onward, my lord.
Paragraph 6 onwards, okay. Grievous hurt has been, read.
The DBSR has been defined under section 320 of IPC. That the injury was, as stated above, is not covered by the first 7 kind of hurt, which was designated.
See, one step on our abdomen, left loin,
Yes,
5
left loin.
centimeter to 2 centimeter.
Yes,
Omentum exposed
exposed.
through the wound. No vital structure injured. According to doctor, injury was fresh caused by sharp weapon and grievous in nature.
Yes,
Now it says the grievous hurt has been defined T20, so admittedly the injury was not stated above. Is not covered by the first 7 kind of hurt,
yes.
which are designated as grievous hurt under the above section. There are 8 kinds of hurt which have been 8ly. Any hurt endangers life.
Yes,
The prosecution tried to so and so hospital for 20 days. As such, the injury was grievous. There is evidence of the victim that he was in hospital of about 1.5 months. The evidence of doctor stating that the injured was in hospital so and so. The learned counsel would have submitted that the other evidence the court is not sufficient. The question that emerges, the mere stay in the hospital 20 days or more is sufficient to attract provisions of so and so. In view of the specific provisions available, we hold that the prosecution also must establish that the victim is a result of injury sustained by the sufferer, suffered severe bodily pain during the space of 20 days. So this is a case of the second part.
My lord, here also injury was caused.
Here the injury was
And the-
grievous. Here the injury was grievous and he was in ICU for 5 days.
Yes, in this case, he is for more.
In
than
this
20
case, he was there for 1.5 months.
1.5.
But court has come to the conclusion the prosecution could not bring, whether he is in bodily pain or
No,
whether
us-
whether he was suffering from these things, the prosecution could not prove it. And the injury is only 5 cm to 2 cm, no vital structure injured. That is clear.
Here also, my lord, firstly, he was taken to the PHC.
Yes, in a village,
Yeah.
what they will do,
Then
in
thereafter, he was
a
taken to
village,
Dispur.
what they will do, they will take to the primary
Primary
hospital.
health center,
Then
thereafter-
stitch was given. They thought he'll be fine. The villagers has brought him back to the house. Then he became unconscious.
Yeah.
Then he has to be taken to the Dibrugarh Medical Hospital. There is no material or there is no cross-examination. Yeah, that you have brought the material before this court, stating that he was not there in the Dibrugarh at all. That material is not before this court, that he was not there in the
No,
Dibrugarh.
that material is
No.
not. for this
So-
court. Nothing has been examined on that.
Correct. So you have not examined, you have not cross-examined him. You have not, you could not rebut his statement, father's statement that he was in hospital for ICU for 5 days. So on that basis,
Even my lord, prosecution also did not say the patient was in bodily pain for 2 or 4 or
that
5
is not
days.
required because he's already there in ICU for 5 days. Intensive care unit for 5 days. So if the case you have placed, that is on the question of the second part, or. Because it says that no vital structure injured. If no vital structure injured, then his life was not in danger. But whether he was in bodily pain or not. See, if you're, see, I'm telling you one thing. For example, like somebody's hand is cut very badly. Very badly.
Yes.
Correct. His hand is cut with a sharp weapon. His hand is cut very badly. But his life is not endangered by that. But he may be suffering bodily pain for 20 days. And he may be in the hotel or hospital. So he may be in the hospital, so he may not be in the hospital also. But if he suffers for 20 days pain, bodily injury, if that can be proved, then that is a grievous offense. That's what that the definition is. But in your case,
My lord,
the
it
thing
may be
is,
dangerous for life, but not endangerous, my lord, I think.
that has endangered his life because he had to be there in ICU when somebody is put in ICU.
Death also,
When
my lord,
somebody is in a critical stage of health,
no, my lord.
and when he cannot be kept in a normal cabin, that he has to be given 24 hours medical attention, that he has to be, his health has to be monitored for 24 hours
My
by
lord, if so
expert
serious-
doctors.
Yes, that is true, my lord. If it is so serious, then why he could not produce before a medical college? He was keeping in a private nursing home.
I mean, can you force somebody?
Of course not, my lord.
No, if somebody's
Of course
brother
not.
or somebody is hurt, can you say them that no, take him to the medical hospital only, you cannot take him to the private hospital? Can you say so?
That true, my lord, that true. That incident occur, kindly see that,
Yes, Mr.
was-
I mean, anything else?
no, that is my only submission.
We are, Mr. Ms. Zini.
Yes, your lordship. Lordship,
Then one
I
more
have-
judgment is there, my lord, there is a distinction between comes and danger to life as much as stronger expression than dangerous to life. It is there.
Yes, please.
It was convicted for 307, it was converted
Converted
to
to
326.
326. Because that was
It
for,
was convicted for life,
Hmm.
but later on it was
it
convicted.
was not 30, I mean, grievous injury.
It was
307,
previous hurt,
grievous.
yes.
Hmm.
The offense was, he was convicted for life under section 307, attempt to murder. But later on it was
Yes, from attempt to murder to it has been converted to grievous.
326,
Ah.
yes.
Then it will not be applicable to you.
My case, my lord, since I am in jail since on the date of my lord judgment.
No, you have absconded. What you were in jail?
No, my lord, absconded at that time, my lord.
You were absconding
No,
all throughout. Then after a conviction only you were in the jail.
no, during the trial, I was in
No,
bail.
during the trial you were there. That-
Yeah. During trial, I was in bail.
You have been given bail at the
Yeah.
time.
By the-
Hmm.
During trial, I was in bail. After conviction, my lord, by the appellate court, I was in bail.
Now you are you are jailed for?
For more than, my lord, 6 months. Considering the gravity of nature, my lord, this, though he may be convicted, my lord, period of.
This person would have died the way you have hit him, the way you have hit him. He was riding a bike. You suddenly hit him. I mean, probably, he was lucky that he survived.
No, he roam around whole the day. In the evening, he said, I became unconscious, taken to hospital.
It may happen. And what roaming around? He was, this body part, the biological thing behaves differently on different persons.
My-
If somebody, do you want to say that like only because he is hit, he should have died there only?
If it is grievous, if it is so serious injury, then.
Where he was,
normal person,
now, Anna, are you saying that he was roaming around merrymaking?
no.
Then he came after the
He
injury,
went home,
after the
then
injury, he went home.
Police
after
station,
the-
then after hospital, then return home.
So,
then-
those submissions, submissions will not convince me, Mr. Deori. First thing is that your trial, while conducting the trial, you did not put those questions to him.
Of course, there is a
I
debate
mean,
in the
there
trial,
was,
my lord.
there was no rebuttal of the statements which has been made.
Yes, my lord, there was some.
So,
debate in the trial.
now like, at this stage, if there is no rebuttal, there is
I
nothing
admit,
that
my
is
lord,
admittedly,
there is some defect in the trial.
then and then what can be
the
done?
initial stage.
What can be done now?
There was, my lord, for that, my lord,
With the materials before the court, the trial court has convicted.
basically on the testimony of victim and my lord medical.
Yes.
Yes.
That was some. No,
Paragraph 18 and 19
no,
of
no,
the
no,
judgment.
no, I mean, if two testimonies are sufficient to convict him, why you need 100 testimonies? Why do you need to bring more people? It will come. If one testimony is sufficient and it is believable and it is reasonable doubt, it is beyond reasonable doubt that he has done the thing, then why not?
But only the nature of injury, assuming there is a injury was there.
See, injury is there, which is 12 inches. You could not rebut that. You did not cross-examine him anything on that. So on the face of it, it's a 12 inch injury.
Yeah.
And he had to spend 4 or 5 days in an ICU. That is not rebutted.
But whether it is endangered or dangerous to life.
I don't know now what is the life is endangered or dangerous to life. What is, I mean, you tell me now what is the difference?
My lord, dangerous of life is more danger. The more stronger than the dangerous to life. Dangerous is little bit lighter.
So in your opinion, this is dangerous to life, not endangered.
Yes.
It was not endangering to life. Okay, yes,
Right.
Your
Jeannie.
lordship, Your lordship, for this endangered and dangerous life, I have just a citation from the High Court of Punjab and Haryana. This is a division's bench authority, your lordship. And paragraph 11, your lordship, starts with paragraph 11. I'm relying on paragraph 11, 12, 13 and 15, your lordship.
Paragraph 11.
12, 13 and 15. 13, 14 and 15.
Hmm.
If I may read, your lordship.
Yes, yes.
It appears that the doctors who had been conducting the medico-legal examination have been using the term dangerous to life as synonymous with an injury which endangers life. Even the court at times have considered an injury described as dangerous to life as an injury, and we say in clause 18th of section 320 of the Indian Penal Code. In this regard, reference can be made to Muhammad Rafi versus Emperor, IR 1930 lay 305. In that case, the injury was on the right side of the neck, about 21 by 2 inch in dimension, inflicted with a sharp-edged weapon. The doctor had, in fact, in that case, deposed that there was every possibility of the deceased surviving, but for the wound becoming septic, apparently as a result of it being pressed with hands and bandaged with dirty clothes in initial stage before the deceased was taken to the hospital. The court held that, though a finding that the appellant knew that this act was likely to cause death was not justified, but at the same time, a wound on the neck must at least be considered to be dangerous to life within the meaning of clause 8, section 320 Indian Penal Code, and therefore grievous. Paragraph 2, Justice Palek 2 in jail, Naren Mishra versus State of Punjab, 1972 Criminal APP R19 held a penetrating wound 11 by 2 into 1 by 2 into chest wall deep on the right side of the chest caused with a bahal and described as dangerous to life as grievous injury, and in the later part of the paragraph called this injury as one endangering life. The expression dangerous is an adjective and the expression endanger is verb. An injury which can put life in immediate danger of death would be an injury which can be termed as dangerous to life. And therefore, when a doctor describes an injury as dangerous to life, he means an injury which endangers life in terms of clause 8 of section 320 Indian Penal Code. For it describes the injury dangerous to the life only for the purpose of the said clause. He, instead of using the expression that this was an injury which endangered life, described it that the injury was dangerous to life, meaning both the times the same thing. Justice K. Tivana in Criminal Appeal so-and-so decided on January 18, 1979 was concerned with the statement of a doctor who had merely externally examined the injury and had opined it to be dangerous to life. The doctor who had performed the operation had not only preferred any opinion. The injury was a penetrating wound with clean-cut margin of the size 11 by 4 inch into 1/2 inch on the left side of the chest, 5 inch below the nipple. The depth of the wound was not measured by the doctor who had given the opinion. In this case, the learned judge did not accept the opinion of the doctor that the injury was dangerous to life on the ground that he was not qualified to say so merely by looking at the injury, and the one who had performed the operation and had seen the damage had not given any such opinion. The learned judge did not go into question what an injury described as dangerous to life in no case would be considered as a grievous injury. Justice S.S. Devan in Criminal Appeal so and so decided on February 8, 1979, this observed as did Justice S.C. Mittal in Jagrup Singh's case that the term dangerous to life is milder than the expression endangers life. He merely followed his earlier decision. Now in this case, Your Lordship, if the injury that was that was treated by the doctor who is PW4 in this case, Your Lordship, it was only till that part that his stitches were stitched and he was given the first aid, and if the case rested on that part, Your Lordship, it would have been defined as a dangerous to life, Your Lordship. However, subsequent treatment, that he becoming unconscious and he being lifted to Dibrugarh and being admitted to the ICU, Your Lordship, will subsequently define as an endangered to life, Your Lordship.
Okay.
Now, if I may, Your Lordship, place another point is that testimony of an injured witness can generally be not considered to generally should be considered to be reliable, Your Lordship. Any injured person will not in any manner, Your Lordship, would make up a story of the injury that was caused to him, Your Lordship. I'll just rely on paragraph 26, 27, 28, 30, 31, 32, and 33, 34, 35, and 36, Your Lordship. Your Lordship, I would
26, 27, 28, 29.
From 26 till 36, Your Lordship. Mainly, these paragraphs are more particularly in reference to the decision decided by the apex court, Your Lordship.
It's on what? Which point?
It's on the point that the testimony of an injured witness is generally considered to be very reliable, Your Lordship. In this case, Your Lordship, the injured victim, Your Lordship, has clearly stated that he was injured, and while he was blood was oozing from his neck, then he approached his family, Your Lordship. Subsequently, they have filed their FIR, Your Lordship. And then his health deteriorated, and then he was taken to the Dibrugarh and he was admitted. Now that admission, because there was a submission being made that there is no report as to the medical his admission to Dibrugarh, Your Lordship. Now it's the testimony of the injured victim, Your Lordship, which should be relied heavily upon, Your Lordship, because
Injured victim as well as the father of the victim.
victim, Your Lordship.
They both
So-
have stated.
My reliance is only on that case, Your Lordship. The others are, Your Lordship, with regard to minor discrepancies, Your Lordship. Even if there is a minor discrepancies during the investigation, Your Lordship, that would not toward the entire prosecution's case, Your Lordship.
Which are the minor disturbances?
The minor discrepancies that they did, the IO did not collect the medical documents, Your Lordship, because otherwise the Caesar witness is at page number 17, Your Lordship, who is PW3, Your Lordship. He has also deposed that he has signed in the he has seen the DAO which was produced
What
before
will be the effect of, the IO stating that he could not recognize the person?
It's Your Lordship will see that the incident happened in the year 2012, Your Lordship. Subsequently, after 5 years, the trial, his statement was taken, Your Lordship. In that situation, because the IO not only entertains the specific cases, Your Lordship, there is no specification as to that he should recognize the accused in the court, Your Lordship. If there is an allegation made by any of the person and there was a issue with regard to the identification of the accused, Your Lordship, that would have been a different case, Your Lordship. In all the other victims, Your Lordship has recognized the accused.
Okay, that's all.
Yes, Your Lordship.
Yes, you are appearing for somebody? You are appearing for whom? Informant,
for the complainant,
Huh?
victim.
victim. You are all our brothers, no? Why you are fighting the case?
My lord, now I am in very awkward position.
Huh.
Even in the statement before, he had no more grievances against the accused
Correct.
being brother-in-law. At this stage, my humble submission would be that as per the conviction was made as per the material on record. So I endorse with the statement, argument made by the VP. That is,
Okay. Nobody, no one is there? Heard Mr. S.K. Deori, the learned counsel appearing for the petitioner. Also heard M.S. J. Gini, the learned APP for the state, as well as Mr.
G. Tara, I'm a positive.
G. Tara, the learned counsel for respondent number 2. No, you are informant.
Information.
You are not party, na?
His party.
You are a party?
Amicus curiae.
Oh, you are amicus?
Yes.
Mr. So-and-so, amicus curiae, representing the informant. Respondent, he has made,
Respondent.
respondent number 2. Hearing concluded, judgment result. Results.
Right.
Next button. Again, so you know, it is
Item number 9 and 10.
Appellate Lords. Relative decision, today is fixed for bail hearing, but PC have not come yet. Kindly instruction may be given to the registry for call for the
Okay.
share from.
heard Mr. So-and-so, the learned counsel appearing for the petitioner, also heard Mr. M.S. Gini, the learned APP for the state. Office report, office note dated 11/3/2026 reveals that TCR in the instant case is yet to be received. Registry to send a reminder for the TCR in the instant case. Let the matter be listed after 2 weeks.
Your Honor, and appearing on BA number 21 of 26, there are 2 bail applications. In
Okay.
connection to the.
In BA number 8, you are appearing, right? Right, BA number and BA number
21.
21, MS,
Okay.
so MS,
Let's be done.
the connected matter. No?
Yes.
Matter may be fixed, Lordship, because I am from Guwahati, number 1. Number 2, the accused person behind the jail since last 5 years, more than 5 years.
Okay, then let the matter be fixed on when?
No.
9.
Huh? 19,
Ninth, my lord.
9th of April.
Yes, my lord.
No, Lordship.
TCR, it will take, I mean, why so much of time?
My lord, because,
It's a bail application. No, it cannot be given so much of time.
my lord,
You are appearing from whom?
I'm speaking for 10.
Huh?
Item number 10. 10, my lord.
Huh?
The leading concern, my lord, he will be not available. because-
No, he may not be available, will not, you are informant only. We are not going to wait for it. It's a bail application. We have strict guidelines from the Supreme Court. It cannot be listed just like that for 1 month, 2 months.
It is 16 to 20.
I mean, listed on,
Inka.
listed on,
Yeah.
today is what? Today is 12.
12.
Let the matter be listed on 19.
PCR तो पहले से बुलाया हुआ है।
हाँ,
Let the matter be listed on 19.
Ablas.
Dip.
List.
Last.
Please come in.